This is the eternal American development war, property rights versus neighborhood expectations. This ties directly into what planners call NIMBYism, not in my backyard. And before people get emotional, NIMBYism is not always irrational. Sometimes neighbors are protecting things like sunlight, privacy, neighborhood character, traffic flow, noise levels, property values. But sometimes it becomes a weapon used to stop any change. And even though today's example that we're highlighting is more or less a first world problem, right? This guy is loaded. This is why housing gets so difficult to build in America. Everybody supports development until it's next door. Now imagine spending hundreds of thousands of dollars, maybe even millions of dollars on a luxury property, getting permits directly from the city, building exactly what the government approved, and then still ending up in jail while being ordered to demolish everything you've built. Tampa businessman Michael Martin built a 2-story guest house, pool, and a pickleball court on a property he owns in the Beach Park neighborhood. According to the report, the city of Tampa issued permits literally approving the construction. But his neighbors sued. They argued the structures actually invaded their privacy and violated rules tied to the lot being considered non-buildable. And so a judge actually sided with the neighbors, and Martin was ordered to demolish the structures, but he refused while he was actually appealing the ruling. Eventually, he was literally jailed for contempt of court for nearly 3 weeks before agreeing to comply with demolition. Now, whether you think this guy is a reckless rich developer abusing the system or a property owner getting crushed by government contradictions, this story exposes a massive issue hiding underneath American real estate, which is who actually controls your property once you own it.
A Tampa businessman was released from jail today after agreeing to demolish his guest house, pool, and pickleball court that sits in his Beach Park neighborhood. Even though the city issued the permits allowing Michael Martin to build it all, a judge agreed with his neighbors who opposed these renovations. Fox 13's Ariel Placencia has been following this story very closely for us. So Ariel, you actually spoke to both sides today. So what'd they say?
Well, Allie, a spokesperson for the neighbors who filed the lawsuit said they are, quote, cautiously optimistic that Michael Martin will complete the demolition. Meanwhile, Martin himself told me demolition will start next week, but added that even though he's out of jail, this fight isn't over.
My appeal was denied, one of the appeals, and my family was, very worried about me and being in there.
That's Michael Martin on why he decided to comply with the judge's order of demolition after spending nearly 3 weeks in jail.
Lost about 12 pounds and a little run down, but it was worth it.
The crazy part here is that he literally got the permits from the city to build what we're seeing on the screen. But hold on, because once the city issues permits, most people assume, okay, I'm safe. The government approved it, we're good. But real estate development does not work that simply. A building permit alone is not some magical shield from litigation. And this is one of the biggest misunderstandings regular people have about construction and development. Let me explain this clearly because a lot of viewers probably don't understand how dangerous this process can be. A building permit usually means the city reviewed submitted plans. Staff believed the plans complied with zoning and building codes, and the project can proceed under municipal approval. But that does not always protect you from private lawsuits, deed restrictions, easement disputes, HOA regulations, covenant violations, neighbor nuisance claims, appeals, or judicial reinterpretation of zoning law. That's the scary part. You can spend millions based on approvals and still lose. I actually understand why Martin kept fighting, because from his perspective, the city told him yes. But if government approval can later become government reversal, what confidence do developers even have left? And if you think this only affects rich guys in Florida, you don't understand development.
We hope he learned his lesson.
Beth Latham represents the Babbitt family, who sued their neighbor, Michael Martin, in 2021 over what's in his backyard.
We hope that he proceeds as committed and as ordered to remove and demolish the structures.
Martin bought several Beach Park properties back in 2017 and reconfigured them through a city process. He took the middle lot and decided to build a 2-story guest house, pool, and pickleball court in his backyard. And he got proper city permits for it all.
I just thought it was kind of crazy town that someone would challenge a city's permit.
But after the South Tampa resident began construction on that backyard guest house in 2021, his neighbors, the Babbitts, raised concerns, including privacy issues.
They can't even enjoy the pool that they have. At one point, they had windows facing into their home.
Now, this is where the story actually becomes culturally fascinating, because this is the eternal American development war, property rights versus neighborhood expectations. This ties directly into what planners call NIMBYism, not in my backyard. And before people get emotional, NIMBYism is not always irrational. Sometimes neighbors are protecting things like sunlight, privacy, neighborhood character, traffic flow, noise levels, property values. But sometimes it becomes a weapon used to stop any change. And even though today's example that we're highlighting is more or less a first world problem, right? This guy is loaded. This is why housing gets so difficult to build in America. Everybody supports development until it's next door. But as a developer, this is why entitlement risk is everything. People think construction risk is labor costs, interest rates, materials. No, the biggest risk is uncertainty. Lenders hate uncertainty. Investors hate uncertainty. And stories like this make lenders even more conservative.
Court documents show the Babbitts reportedly tried to resolve the issue with Martin themselves. But when that didn't work, they took legal action. At that time, Martin, who did have city-issued permits, was reportedly warned that what he was building could be at risk of demolition as this fight worked itself through the courts.
He chose to move forward and build this 27-foot monstrosity.
Then, back in 2023, a judge sided with the Babbitts and ordered Martin to remove everything in the backyard and restore that land to the condition of a non-buildable area.
Now, this phrase really matters, right? Non-buildable area. That's planning language. So what's non-buildable land? Certain parts of land may be classified as conservation zones, easements, setback areas, drainage areas, utility corridors, wetlands, protected open space. What does that mean? You technically own the land, but your rights to build on it are heavily restricted. This is a perfect example of why due diligence matters so much in development. People see land ownership emotionally. I bought it so I can use it. But development law is layered with zoning overlays, environmental rules, deed restrictions, setback requirements, neighborhood plans, historic protections, stormwater rules. In other words, owning land and controlling land are not the same thing. And honestly, this kind of legal uncertainty is part of why housing costs explode, because every lawsuit, every delay, every appeal, every demolition order gets priced into future projects. Studies have shown entitlement and permit delays can add years and hundreds of thousands, sometimes millions, to development costs in major cities.
We asked why he didn't demolish then.
We've been in a series of appeals, so I still have an active appeal.
When nothing was demolished, Martin was found in contempt and arrested. After roughly 3 weeks in jail and the court denying his recent appeal, Martin announced he is complying with the judge's ruling to demolish everything. He was released from jail on Friday, May 8th. He says demolition starts next week.
Yeah, it's starting, but I still have avenues available to me, and we're still working on more action to be taken. The message is, I'm not done fighting. I'm not throwing in the towel.
Now, spending 3 weeks in jail, this is the moment the story stopped being a zoning dispute and became a power story. Because once someone is jailed over non-compliance in a property dispute, the message becomes the courts are willing to aggressively enforce land use rulings. And honestly, some viewers are going to love that. They'll say, good, rich people think rules don't apply to them. Others will say, wait. The government approved the project first. Why did he get locked up? This is one of the many reasons why trust in institutions keeps collapsing, because both sides think they're defending fairness.
And Beth Latham, again speaking for the Babbitts, said she thinks the city made a mistake and that the court rectified it. Meanwhile, Michael Martin told me that he would consider suing the city. And in a statement, the city of Tampa told me, quote, the court ultimately ruled that the area in question was not buildable, a decision that was later upheld on appeal. This is a legal matter between the litigants and the courts.
If the city truly made a mistake, who pays for it? This gets into a massive issue in development law, municipal liability. If a city improperly approves permits and a developer relies on those approvals financially, there can potentially be legal exposure. And this is why developers sometimes stop investing in cities or decide not to invest in a city, not because they hate communities, not because they're greedy villains, but because unpredictability destroys confidence. Think about the message this sends. Trust the permitting process unless we later decide you shouldn't have trusted it. That's a terrifying precedent. Now, he mentioned that he's thinking about suing the city, and honestly, I'm not shocked. There's a concept in development disputes called reliance, which means did someone financially rely on government approvals? Because if he spent major money based on city-issued permits, his legal team is probably exploring whether the city bears some responsibility. And that actually matters nationally, because if developers begin fearing permits are reversible after construction, you're going to see higher insurance costs, more legal contingencies, more consultant reviews, fewer ambitious projects, and slower development timeframes. And America already struggles to build housing efficiently, so every story like this creates ripple effects literally beyond just this one luxury property we're talking about. But the scary part here is how most smaller developers would never survive this financially. But this story is uncomfortable because there's truth on both sides, right? Neighbors deserve quality of life. Cities must enforce planning rules. Courts matter. Property rights matter. But if approvals can collapse after construction, what exactly does ownership even mean anymore? Okay, can we also acknowledge something funny here? Pickleball has quietly become one of the most controversial things in affluent neighborhoods. Why? Because the sound frequency from pickleball paddles creates repetitive, sharp impacts that neighbors complain about constantly. Cities across America are now debating court setbacks, operating hours, acoustic barriers, zoning requirements. That sounds silly until you realize quality of life complaints drive real political pressure. You know your neighborhood is wealthy when the major community battle is the pickleball acoustics are ruining sunset wine hour. I don't know if that was really funny. I just wanted to throw that in there. And that's why this story matters way beyond one mansion in Tampa, because underneath the headlines, this is really about who controls cities, who controls neighborhoods, and how much power property owners actually have once politics, courts, and community pressure collide. But I want to hear from you. If the city approved the permits, should the owner be protected, or should neighbors still be able to fight projects after approvals happen? And if you spent millions building something legally approved, would you stop fighting? Thanks for listening to me ramble. I do have a Patreon community, and that's where I share a lot more of a low-level vantage point of real estate development and entrepreneurship. Would love to welcome you over there. See you in the next video.